Good morning and welcome to the 35th meeting of 2025 of the Economy Fair Work Committee. Today we will be holding our third evidence session on the Digital Assets Scotland Bill. And I'd also like to note that we have apologies from our colleague Lorna Slater and our colleague Sarah Boyack may or may not make an appearance as she is moving amendments at another committee this morning. But we are very pleased to have with us this morning Greg McClarty, founder and CEO of Two Hands, Professor Jill Robbie, Professor of Property Law and the Natural Environment from the University of Glasgow, and Professor Burkhard Schaffer, co-investigator Decade, is how that's pronounced, the Centre for the Decentralised Digital Economy. I would just ask our witnesses if we can we'll have concise questions from committee members and concise answers that will help us get through what is an expansive topic, as we've been finding so far in our evidence sessions. And I would just like to begin by opening up. This is a short bill, one that essentially has the aim of bringing digital assets into Scots law. And I really just wanted to ask both whether that our witnesses feel that is the right approach, and then also in detail whether they think the way that digital assets are defined works, because clearly the definition depends on the fact that these assets arise from electronic systems, that they are rivalrous, and there's an immutable record, and I think making sure that those concepts will work, I think, is important. But just in terms of that broad approach, in terms of a narrow bill, simply just to bring them into Scots law, does the panel feel that that's the right approach, or are there any other aspects that they feel the bill should be covering off? I'm very happy to go to whoever would like to answer that first.
Thank you, Convener. I should note I'm also Deputy Chair of Nature Scot, but I'm not giving evidence in that capacity today, but just for the record. I think that this bill seems quite discreet in a sense. You might think that this is just a kind of technical change to Scots property law, but I think the implications of this bill can be quite large, and I don't think they've been sufficiently considered. So I think this bill has been drafted on the basis of cryptocurrencies, but I think the implications are much broader than that. And I think Greg McClarty's evidence is really excellent for demonstrating the range of assets this could include, and I just don't think we have considered the consequences of making all of those assets property. So my particular concern is carbon units and what the potential effect is of making those property assets. And the bill, and indeed the policy memorandum, the explanatory notes, the reports that have preceded any of this legislation have not considered the impacts of propertyising carbon units at all.
What do you think the potential consequences of that are?
So my fear is when you make something property, when you define it as an asset which is capable of ownership, you then prevent possible future regulation, or you make it more difficult. So we can see that in the context of land reform, when you're trying to change ownership structures or put in more regulation. First of all, you need to prove it's in the public interest. Second of all, if you change your mind and want to expropriate those assets, you need to give compensation. We don't know the scale of implications of this bill, and I think it restricts government and future governments in regulation and further governance of these types of assets.
Greg McClarty, maybe I could bring you in since you're a reference there, and just to sort of elaborate on that a little bit. I mean, I think it is, I think one of the things the committee have been noting that this seems to have sort of cryptocurrencies and other such things in mind. And yet what we have is a very broad and expansive definition that's certainly not limited to those things. Do you think that's a sort of a fair characterisation? And secondly, what would your thoughts be, and especially in reference to what Professor Robbie has just set out?
Yes, and thank you for the invitation, convener and committee. So we're approaching this. We've been commercially involved with blockchain and digital trust technology for over 6 years now, and we think it's got significant potential, as I hope to convey this evening, or this morning, sorry, your time. And so we're working with a collaboration of 7 other companies, and together we think that this bill is elegant. In terms of, we find it provides clarity and to what is an asset from a property point of view, and we find it invigorating in terms of where we want to take this technology to drive dramatic impact with farmers and fishermen, regional communities, and impacting net zero. Now, in terms, frankly, and we do think with that elegance in the bill that there are changes we would like considered in terms of 2 factors. One is the ownership and exclusive control provisions that we can discuss later on, convener. And secondly, while I truly stand shoulder to shoulder with what Professor Jill Robbie, what her concerns. We share those concerns because it's driving dysfunction in the market in a number of ways. But what we see, convener, is that we see as a bit of background, convener, that there's a group of the EU and its great wisdom undertook a forensic analysis of carbon inventory and greenhouse gas emissions on 7 farms in Northern Ireland just to understand what was happening with carbon and GHG on farms. And that was in 2014. Here we are 11 years later, and all 7 farms, 5 of which carry livestock, are targeted to be operating beyond net zero by 2030. If you scale that across Scotland and the UK, that agriculture alone will bring Scotland and the UK to net zero, the entire economy. So it's an extraordinary opportunity, and what this bill does is that it takes that forensic analysis of carbon and greenhouse gas emissions and biodiversity, makes it an asset, and so then and I love the rivalrous and the immutability elements of the legislation, convener, because what the impact it has is that back in 2021, globally, 800 billion was invested in carbon offsets. That market collapsed at the end of 21 because of a lack of rivalrousness. And so they found that they were selling trees and plantations multiple times. And so we've got the technology now where we can deliver with the rivalrousness and the immutability. We can now make those certain assets that, and we've been informed by one of the world's leading technology companies that they would be willing to come back to the carbon offset market if we can prove in Scotland that we can use blockchain technology to authenticate the the assets, and what that will do, convener, there will be no need for.
If I could just intervene, I think we are sort of touching on some of the points that I think some of my colleagues may bring up in terms of tokenisation. Thank you very much for those remarks. I just wondered if I could bring in Professor Schaffer, and then I actually would quite like to just return to those points about the terminology, particularly kind of the rivalrous and immutability points, and whether those are well understood. But Professor Schaffer, just, I mean, do you have any sort of thoughts in terms of the overall approach? And indeed, given that I've already sort of flagged that I was going to ask about those concepts, given that they are novel concepts, again, if you have any sort of contributions on that.
I mean, both in a personal capacity, but also from the stakeholder activities that we carried out as part of Decade, I think there was generally broad support for the legislation. It was seen as both necessary and appropriate the way it was worded. There were obviously concerns, especially from the industry community, on whether it was precise enough, detailed enough. My personal view on that is it gets the balance right. It makes very clear that there are certain assets that will definitely fall under property, but it leaves enough space for future developments. There might well be things that will not be called blockchain or are using some of the ideas, but not all of them. And it is perfectly normal, I think, for legislation to have that distinction between a core that is settled and then the flexibility to move forward. So again, I'm a blockchain skeptic, I would say, in general, despite my membership of that group. But I do think that some of the anomalies that we've seen in that industry can well be addressed better if there's a clear conception of property and ownership underlying it. I totally agree with Jill Robbie on the dangers that we face in, for instance, carbon trading. But I also think that granting property or ownership, if there is a system that actually really matches the requirements, is not harming substantially the ability of future parliaments to regulate. Quite on the contrary, it tells you whom to regulate. It clearly identifies now someone who is the owner. And then you can think about taxing or taking away or in other ways limiting it, which is, I think, despite obviously the human rights implications that have to be taken into account, still easier and more straightforward than these complex contractual networks that we see at the moment. So on that ground, broadly speaking, very much in favor of the way the bill words this.
And just to my second question, and maybe ask you, Professor Robbie, in terms of the concepts of immutability and rivalrousness, those are novel terms in Scots law, as I understand it. I mean, we have heard and taken evidence that people feel that they are sufficiently clear, but obviously, as legislators, when there are new words being used, we have to ask the question whether they are sufficiently clear. I mean, I also note that you know, when you're looking at legislation elsewhere, and you know, Australia has recently brought forward legislation that they talk about. I think it literally uses terminology such as exclusive control rather than, you know, rivalrousness. Is there? Do you feel that the terms are sufficiently clear that they will work as we incorporate them into law?
I don't think that this clarifies the status of all potential digital assets. So this, I don't think, is going to result in no litigation. It's not like this is clear enough and then we move on, this problem is solved. There will be new technological developments, and then there will be questions about whether existing assets fit into this definition. So, for example, carbon units. I've already had debates with people of whether the voluntary carbon market that's existing in Scotland, whether those units fit into this definition. So you probably will have then litigation that results in a requirement for a declarator about whether a particular asset fits this definition.
I think it's probably fair to say that, having heard from previous witnesses, I think the point isn't necessarily to avoid litigation, it's so that when it does happen, that we at least have some sort of hook or purchase. I mean, do you think that's sort of a fair observation?
Yes, but it's interesting to think. I think some arguments are this provides certainty, kind of full stop, and that's not the case. No. This provides a structure for decision making and characteristics. There's still does this asset meet this definition to result in the protections, and that will be an ongoing process.
Thank you. Mr. McClarty, I mean, and you touched on those two concepts. I mean, do you think they have sufficient clarity and purchase on this area of digital assets and electronic property?
Yes, Convener, for where we're at right now, and I've got to say, I love the testimony from Lord Hodge, Professor Fox, and Usman Tariq and the other learned witnesses. That clarified a lot to me in regards to the interpretation of those words and definitions, and so I think they are fit for purpose.
Thank you. With that, I'd like to give the floor to Stephen Kerr.
I'm not a lawyer. I'm certainly not a professor of any of these matters. So some of the language and some of the terminology, some of the new words continue to kind of not quite bamboozle, but nearly bamboozle me. So I am turning to you, Joe Robbie, because you expressed concerns very forcibly this morning, actually, about the A1P1 implications of the bill. But I'd like to ask you to expand on that, please.
So my concerns come from my research into voluntary carbon markets. And the way that we have voluntary carbon markets in Scotland is that a landowner can register a tree planting or peatland restoration project. They register that on the UK Land Carbon Registry, and then they can sell carbon units. Carbon units can then be bought by companies that offset their emissions so that they can claim that they're net zero. The operation of these markets has resulted in a lot of fear that tenant farmers are getting limited, they're getting evicted from the land, or not, their leases are not getting continued because landowners want to engage further in carbon trading schemes. So there was a heat in the land market for a while before discussion about regulation of these carbon markets continued. So with the context of the continuing concerns on the carbon markets in Scotland, making those units property, along with the A1P1 protection, limits the ability of this government and future governments and parliaments to regulate and control some of the negative consequences that might come out of the operation of that scheme. So that could be implications on food production, on the position of tenant farmers, on crofters. That these debates are still ongoing. So I keep getting questions about, can you tell us the legal status of carbon units, please, so that this can be clarified more in a more certain way in the law to allow agreements to proceed. My fear is that is not, the discussion of the implications of all that is not in this bill at all. Land reform, as you know, is an ongoing process. I tried to get more regulation of carbon markets into the land reform bill, but I think that was beyond scope of the bill. That's just one example of a digital asset that can have consequences because it's recognised as property. I'm sure there's more.
Well, how would you change the bill then?
For me, take carbon.
At all?
Well, I would take carbon. I would say simple amendment, take carbon units out of the bill.
Right.
So digital assets do not include carbon units, because I think we need to first of all regulate the operation of carbon units in Scotland, and that has not happened. So carbon trading takes place because there's 2 carbon codes which are literally just PDFs and a website, and that can be, people are exchanging value because of those units. Because of this bill, those can be recognised as a new asset class, which is a property object. That's a big change. Usually we're used to thinking of property as, physical things, or we have an established system of transfer of debt and security and all the financial system, but the steps you have to take to just create a new asset are actually quite minimal, and I'm worried about this. What happens when you try and regulate that in the public interest?
The voluntary carbon credits you're talking about, or are there other things which I think of as intangibles? I think that would come under the bill that could potentially have a detriment to future policy, to the consumer, to the environment?
Yes. So Greg lists, for example, in his response, a number of ways in which physical items or data, for example, can be tokenized. And he then thinks about how the bill can be adapted to support the propertyization of these things. And that's very useful because it shows you the scope. My expertise is carbon. That's the thing that I've been researching and the thing that I'm concerned about. I've written a paper for the Scottish Land Commission about it. So that's been my fear. But I think when I look at this, I see carbon units. I'm sure other people see other things. But that's almost my point. We don't know where this can go. And
right.
If we don't know exactly what the scope
You're
of this
making it
bill
sound like some kind of Pandora's box.
Well, I mean, property is powerful, right?
Yeah.
And if you've seen the debates on the land reform bill, when you try and change the property arrangement, there's challenges to that. So it's about who you are benefiting from recognising things as property. And from a land reform perspective, with carbon units, we're creating a new asset class that's attached to land, and we have concentrated land ownership in Scotland. So that's my big concern as well. You make a new asset class attached to a resource that's already in the hands of few people.
Yeah.
I don't know who would be benefiting from the propertyisation of cryptocurrencies. I'm not sure it's the most disadvantaged in Scotland. So there might be other implications from this that's what I'm worried about.
Right. Okay. I mean, I can tell that we're straying into other areas, and I know there's a colleague that wants to come in on tokenisation, but I feel like I need...
I think Mr McClarty was hoping to come in.
I was turning convener to... because Greg McClarty was referenced. Your response?
Yes, Stephen. We stand shoulder to shoulder with Professor Jill Robbie on this issue. In regard to estate owners and landowners, there is dysfunction with the Woodland and Peatland codes. What I suggest to the committee is that the issue is not with farmers who are actually producing farm product, livestock crops and the such, and for those groups, there would be very significant benefits from it's not just carbon units, but you need to include greenhouse gas emission as well, but biodiversity and water. And so what this will do, it will drive wonderful incentives for farmers to address these issues. The issue that Jill Robbie is concerned about is in regards to landowners who see the extraordinary gains that are coming through the woodland and peatland codes is driving dysfunction in terms of, well, no, we're not going to give a tenant farmer a long lease anymore. We'll give the tenant farmer 1 year, 2 years, and it's creating all sorts of issues in that regard. So what I would suggest to the committee is that if it's a productive farm, then allow these assets, because it will drive a really important additional income for the farmers, and it will have a dramatic positive impact on net zero and biodiversity. And so we need to carve out the issue here from the woodland peatland codes in regards to estate owners and landowners who will then take away productive land and to take advantage of these codes. So that's specifically what needs to be addressed. But for the greater good of Scottish farmers and their regional communities, and addressing important environmental impacts, I would say it's very important that they be isolated in the bill and treated as an asset in accordance with the definitions.
Right, and what are the other ramifications of the issue we're discussing around voluntary carbon credits? I mean, are there other implications that we've not heard about yet? We've heard a lot about carbon. Are there other implications?
Other implications, well, for farmers, what it would do, it would drive. There's lots of positives for farmers. It does drive dysfunction.
I'm thinking more of
it does drive dysfunction with. Sorry, go on.
Sorry, Greg. I'm thinking more of other potential risks. We've heard about risks from Jill Robbie and yourself in relation to the carbon credits, but what are the other potential risks that there are in this bill?
Other risks? No, I wrote a lengthy application, Mr. Kerr, and I think a lot of those can be addressed with regulations after the bill is enacted. So I don't, at this point, see major risks that need to be separately dealt with in the bill, other than what I mentioned about ownership and exclusive control provision, but I believe we'll probably get to that.
How does this bill, you described it as elegant in your opening remarks, but how does this bill compare with existing legislation, for example, in Australia?
Yes, Australia is about 2 months behind Scotland. It's only 2 weeks ago they first introduced legislation into Parliament, and that is firmly focused on just regulation in terms of financial services. And so the context for the Australian legislation was the coward boy, the Wild West market in 2017, 2018 that had two very high profile collapses with FTX and Celsius, creating between $8 billion and $12 billion US in asset failure. And so the Australian bill is firmly focused on that. It does not do anything past financial regulation.
Okay, thank you. And Professor Schaffer, your comment on this bill in the context of, for example, law in the rest of the United Kingdom?
Yeah, I mean, for me, there's a difference here between the bill and what will happen in terms of interpretation of the bill by the courts as we move along, in particular to potentially quite different technologies. So what I think personally, and made that clear both in England and I think also in the written submission here, is that we would benefit from having a officially recognized body, a mixture of academics and industry that gives guidance, just in the same way in which the data protection authorities can give guidance on how to interpret laws. which would not preempt judges from diverging from them necessarily, but create this or fill this missing gap between what the law says and what industry needs. So that would be the one thing that I might have added to address some of these concerns, that it is difficult to regulate in a field where technological change always seems to outstrip legislative capacities. As Greg said, quite a lot of the existing bills that are discussed now are responses to something that happened in 2018-19. And getting that balance right is very, very difficult. But I think given the expertise we have in Scotland in particular, it's better to leave that to a separate body of experts that can guide the development without having the power of legislating. In terms of the carbon credits, of which I don't know enough really to say something very, very profound, but it still seems to me there's a difference between the ability to call them digital assets and then their regulation. And some of the problems that Jill mentioned, a conflict here between a tenant and the landowner. Well, the problem here seems to be a property law problem, but the property law problem is that of tenancy in our land ownership. So for me, it would be better and more straightforward to address any concerns that arise there in the specific laws that apply to carbon credits, to say there how they are going to be calculated, what is permissible, what is impermissible, and then use this bill as a sort of backup. And if you comply with all of this, then you will also get property rights rather than the other way around. Yeah.
I mean, I honestly could ask 1,000 questions because I feel like I need a private tutorial from each of the three witnesses this morning to even begin to get my mind around so much of what you're talking about. But I suppose from a lawmaker point of view, my concern is that definitions in the bill are adequate and don't result in immediate legal action, which I think, Jill, you kind of alluded to, or did you, or did I misunderstand? I mean, is the definition of a digital asset sufficiently clear in the bill that it won't create more uncertainty by and of itself?
I think, as the convener mentioned, I think it almost provides the structure and the set of criteria so that when you raise an action in the courts, you will have clarity by meeting these criteria.
Right.
So it doesn't clarify, for example, carbon units. You could probably write an academic paper about whether carbon markets meet, the carbon units meet these criteria.
Yeah.
And I'm sure there are other assets which will again be subject to that kind of analysis. But then there will inevitably be somebody who raises an action for declarator in relation to this bill to clarify.
There'll need to be litigation around these.
And the policy memorandum explanatory notes anticipate that by saying, the courts will clarify X, Y, and Z.
Yeah.
Again, are the courts best placed to clarify those particular things? Yeah,
I just worry that we create law that then creates an opportunity for lawyers to send bills to people that, which
I actually don't support generally.
No, and clearly I don't either, and hence my conundrum. Professor Schaefer?
We do have in Scotland the possibility of asking for a declarator. Yes. That is obviously a mechanism that doesn't exist in that form in England, and that could in itself be a motivation for more potential asset holders to get clarity. I don't think it would be a major problem. There might be a small increase for certain key contested issues, which then will be settled by the courts. But normally speaking, I would say, these issues arise if there is a conflict. If they're
not comforting, last note, I will pass back.
And without obvious conflicts arising, apart again from certain fringe issues, I don't think there would be an unmanageable increase. It would be the type of manageable increase that clarifies things, where we then get court decisions. Again, I would maybe hope that they are informed by the best available evidence in Scotland, but one way or the other, they would then put down the markers. in putting up something both of you mentioned earlier, and also Greg in his testimony, lots of other countries are now legislating here. Australia is, the US has done so already, but these are either very, very specific Bitcoin and financial services laws, or even slightly wider blockchain laws that also cover NFTs. But they are very, very specific in that respect. And I think this is the first one that I've seen that really creates the opportunity to expand beyond that if it is seen workable. Yep.
If it is seen workable.
Yep.
Yeah, I was going to end on a comforting note, and you've just discomforted me. So back to the convener.
Thank you very much. I'd like to hand over to the Deputy Convener, Michelle Thompson.
I think we've already skirted around tokenisation quite a lot, and I think you led off on that, Greg, so perhaps we could return to it. We heard evidence, I think it was last week, from Professor Buchanan, who broadly explained the three types of tokens: payment tokens, utility tokens and security tokens. And carbon credit, for example, we could regard as a utility token or as a security token. But I suppose my question is bigger than that. To what extent is it an issue, in your opinion, firstly coming to you, Greg, that the bill is mute on tokenisation, bearing in mind the speed of change in this area? So is the prevailing approach a sensible one, and I suppose that means bearing in mind that modifications will need to be made in relatively short order, but it's better to have something than nothing? Or would you see it that it's quite an issue that the bill is mute at the moment? So, opening to yourself first, Greg.
Thank you, Deputy Convener. I'm so glad you asked this question. I love Bill Buchanan, and I heard his testimony, but what we say within two hands is let's crawl before we walk, before we run, and that to a large extent that's what this bill is about. Now, we use a term called the innocence, and we at two hands, and I would think that the Parliament too takes very seriously protecting those who are vulnerable. What we define as the innocence is that there's 51,000 farmers in Scotland, 4,000 fishermen. 99% of those are small family-owned operations who we want them focused on farming. We don't want them focused on technology and all the matters that we've discussed so far this morning. And so to protect the innocents, and the innocents also include family-owned butchers and supply chain participants. And so to protect these innocents, we're necessarily starting in our company in a private ledger. So it's not it's permissioned. It's not permissionless. And so what the path that Liechtenstein's gone down, and what Bill was talking about, is going to the purity of blockchain technology to a permissionless ledger. But in our view, the gaming industry has been using cryptocurrency for a number of years now. What they've taught us is that there's always a few people who are going to game the system so they get disproportionate returns. We can't let that happen to the innocents. And so we start in the private ledger, and we're going to move to a Web3 environment, which will be a world first in Scotland. I think it'll be done in Scotland. It'll be a world first. But we must start in a controlled, centralized environment to make sure that when we do take it to the wild, when we do take it to a permissionless system that where there's a potential for gaming, that we are protecting the innocents. And so the legislation does that, Deputy Convener, and I love that aspect of the legislation.
Okay, that's a very positive endorsement. Professor Schaffer, do you want to come in? Again, going back to my question, to what extent is it a gap not actively considering tokenisation, or do you concur with Greg's view?
I think I, broadly speaking, concur. Tokenization will take away some of the certainty that comes through a digital asset. The cow that then gets tokenized for the market still is the cow, and there are all ways of falsifying it, manipulating it, and so on and so forth. So for me, the important thing would be to say there are certain assets here that you have no control over, and that's fine. What they mean once we move beyond these assets into the real world will depend on the laws that apply there. So we had this problem, I think, with the early attempts of creating NFTs to help artists finding new sources of income. And it didn't work, I think, ultimately, partly because the transition from you own this NFT to you have the copyright in the associated art didn't work. But that was a problem of copyright law. That was not a problem of the law of digital assets to the extent that it existed. So I would say tokenization will be massively important. I think this law provides the baseline, and I totally agree. It provides the baseline in ways that are probably more benevolent to the weaker party, because it is an individual right that is now created, while still leaving quite a bit of the significant problems that we will have with a tokenized industry to the relevant legislative environments. There is a difference between selling a work of art on the blockchain versus a cow versus a carbon credit, and the relevant legal regimes still play a role. They just piggyback on the ownership regime.
And Professor Robbie, last comment from yourself. I'm obviously interested in your view, but what role do you see for guidance in the bill as this emerges? Because obviously there'll be a sweet spot between a sensible approach in the framing within the bill as a first step, protecting the innocents, as Greg says, but also utility of the bill in a fast changing environment. I'd appreciate your additional reflections on that.
I think Professor Schaefer's suggestion of an advisory or expert group that provides guidance is really useful, particularly one that can consider the ongoing consequences of propertisation of these particular assets. Because I thought a lot of what I'm talking about is we don't know the consequences of this and how it might interact with other areas of law or other priorities we have in Scotland as a whole. And I think if we have an ongoing review that can then change or amend or provide guidance in a particular direction, I think that's great. I would just comment that it's the same thing, but once you do recognise something as property, it is more difficult to regulate. So it's difficult to backtrack once a thing is recognised. And that's actually what is the purpose of the bill, is recognising as property so it gives certainty to the market actors.
Yeah, and I suppose following on from that allows for lawyers to do what they do best in terms of now there's a lot of laughter there about what people think lawyers do best. I am making no comment on that. What I meant was allows lawyers to, as individual scenarios may emerge, to really interrogate, to allow the formation of precedent, is what I meant.
Yes.
Okay.
Yeah,
right.
I think that is helpful. And I think from our perspective, we're all giving perspectives on the bill, and your previous witnesses have done it from our own point of view, but it's difficult to see the effects in the round of this because it's a technical amendment that could have all these different consequences.
And I think the framing of the bill in this way is allowing for the recognition of that uncertainty, because we are where we are. Okay, thank you very much. Thanks, Convener.
Thank you. So having discussed that lawyers will do what lawyers do best. We now turn to the lawyer on the committee, Murdo Fraser.
Thank you. Thank you, Convener. Good morning to the panel. I'd like to touch on a slightly different topic from the one we've talked about so far, and that's the issue of trading in digital assets, and particularly the protections in the bill for the acquirer in good faith. I'm just interested in any thoughts you have around that subject. First of all, the principle that acquirers in good faith get a protection that clearly acts to the disadvantage of the original owner of the asset, and also whether the definition of good faith in the bill is sufficient. Who would like to start?
I can try to start. This is a difficult one. I think fully in favor of the underlying principle of good faith acquisition. It has served us well in all other fields. I think, therefore, there's a presumption that it will also work in this field. I think what counts as good faith can be a slightly different question. And there the question again becomes, to what an extent should the legislator put signposts in there, and to what an extent is that left better to either the courts or some interpretive gremium. I do think that blockchain in particular comes with abilities for the purchaser to check correctness of the chain, in essence. That probably didn't exist in the past. When I go to the market and buy something, my ability to check has this been correctly bought by the seller is very, very limited. Here we have, in theory, these more extensive opportunities. We could simply leave that as a question of fact for the courts, reflecting common practice. As long as people use these technologies who are more familiar with them, which I still think is at the moment the situation, we can very easily raise the scales for what counts as good faith. Should they become, like Greg indicated, something that farms simply do as part of their working without becoming technology operations, we might lower that again. So there is this flexibility on what counts as good faith. I would probably still prefer some legislative guidance here that takes the different nature of the digital world slightly more head on. But that is a real nuance, I think. Yeah.
Okay. So if I just press you on that a little bit. When you say legislative guidance, what do you have in mind?
On the one hand, and again, I also agree here with Greg, I think the bill is very elegant. I would definitely not want it to clutter with too many provisions that are very specific for a specific technology. But something like saying what counts as good faith is dependent on the technology in question, something that makes the connection explicit, that there is a different world here in the digital realm that will have slightly different ground rules. That would, I think, what I would like to see. But it's not something that, again, not a hill I'm willing to die on. It is when I read it, an intuitive feeling that the difference between the digital and the traditional physical world really matters when it comes to good faith and what we expect of people to have done in terms of scrutiny.
Okay, thank you. I'll maybe go to Greg McLarty next, if that's all right, and then back to Professor Robbie. Greg.
Yes, thank you. So, Professor Schaefer, I love what you said, and I certainly support what Professor Schaefer has said. And let me give some context again from an agricultural and food systems point of view, where you have farmers who, on average, they employ 3 people, and they're focused on farming, not on digital trust or carbon units or the such. And so the innocents are up against big food, and what's happening at the moment, because there's legislation that's ESG legislation that any company with over 500 employees, and so that's all the major supermarkets and big hospitality players, as well as banks and insurance companies, have to report ESG under legislation. And so they're forcing farmers to undertake activity. And they say, listen, we're buying off you. You have to do this. Otherwise, we're not going to take your supply anymore. And there's also other companies who are taking the farm data and calling it their own. And there's not a fair value placed on that. And so I would like to see, as Professor Schaefer has said, something that protects the innocents, where you have the power of big food and farmers who don't have the sophistication about these digital assets.
Okay, again, can I ask you, Greg, maybe to expand on that? You say you want something to protect them. What more specifically have you got in mind?
Oh, honestly, what I would love, maybe it's not for the, because I do love the elegance of this legislation, maybe a regulation as soon as possible after the bill goes through. Honestly, I would love for it to be recognized that farm data and farm digital assets belong to the farmer, full stop. And so, because everyone out there at the moment thinks they can just bully farmers and take the information, and that's got to stop. So I would love to see, especially seeing we're talking about the innocents who are less sophisticated and they don't have the power to have insurance and employ lawyers. And so I would love to see specific mention that farmers own these assets.
Okay. All right. Thank you. Professor Robbie?
I think protection of a good faith acquirer is kind of it's a valid policy choice. It exists other places in Scots property law in general. When you started talking about defining good faith, I got slightly nervous from like a doctrinal point of view of what would this mean for other things, so corporeal movables or heritable property. But what Professor Schaefer says in relation to digital assets, good faith can include or is dependent on the particular technology. That makes sense. So you might have certain due diligence requirements for good faith in relation to X, Y, and Z. But I think it sounds like it's difficult to demonstrate. We're all often protecting publicity in the context of Scotland. So if you have possession or you're on a register, then you can rely on that. And that makes you in good faith unless you know more, which then puts you in bad faith. I can see that that's what this is trying to achieve. So I think that is just a valid policy choice.
But the bill at the moment, although it talks about good faith, there is no mention of due diligence. So is in your view, therefore, is there an implication that good faith means the buyer has to do due diligence? Well,
good faith, I think, in Scotland in general is mostly that you're not in bad faith. You don't know anything that could potentially interfere with the title of the owner. And you're allowed to rely on certain things like possession or registration. How that interact, in relation to if you are in exclusive control of a digital asset, that indicates that you are then entitled to transfer it.
So, final question then on this: is the bill fine in this respect, or do you think it needs to be improved?
From this perspective, I don't see a problem. To me, it's just a policy choice, because you always have to make a policy choice. Who do you protect, the original owner or an acquirer? And now this is the choice that's been made.
Okay. Professor Schaefer?
Yeah, no, I mean, basically, I agree. There was a thought I had just when you were talking, and now it's gone again, which just shows the difference in age. and really taking up Greg's idea of private data ownership, because that would allow me to take my notes and control them. I think in the due diligence aspect, the one thing you want to avoid is people getting an incentive to be more stupid than they need to be. Exactly. The sort of willful stupidity, which the law caters for, but maybe not always quite as aggressive as one would think. Here in the digital field, that could really be a problem, that people refuse to take relatively straightforward ways of diligence to take into account. That's, again, why I think maybe making this slightly more explicit could be an option, but as Jill said, probably general applicable law will see to that anyway.
Yeah. Otherwise, we rely upon the court to decide whether willful stupidity counts as good faith or not.
Yep.
All right. Thank you, Convener.
I have to say, I love the principle that the law shouldn't enable people to be more stupid than they have to be. I think that's, we could almost leave the evidence session there. But I'd now like to bring in my colleague, Willie Coffey.
Thanks very much, Convener. Good morning, everyone. I just wonder if I could ask for some comments on the international kind of dimension to this and how Scotland's bill fits in with that in your view. Professor Robbie, you've spoken at length about wider implications being unknown, of course. Have you come across any examples, cases in other jurisdictions who've dealt with the issues that you've explained to the committee, and how perhaps have they tried to resolve them?
It's not quite international, but of course England has just passed their respective bill, and that does make it more likely, I think, that there's pressure in a Scottish context to match recognition of digital assets in a similar way. But I don't know anything beyond. I don't know any other international examples in relation to recognition of digital assets as property.
Professor Schaefer, Greg, any other examples? We know that, Greg, you said Australia is maybe a couple of months behind Scotland in the legislative journey here, but have you other examples, Professor Schaefer?
From our stakeholders who are sometimes internationally operating companies, and still they were broadly in favour. They couldn't see any conflicts between the Scottish approach and, say, the US approach, or whatever legal system they worked with that would cause them concern. They, in principle, liked the idea of increased certainty through the recognition of digital assets. They probably still felt they could work around this if it doesn't happen, to be totally honest, especially the very, very big ones. But there was no concern that this would force them to abandon Scotland, abandon the UK. So that was pretty much the feedback, and that is in line with my understanding of the law as well.
Mm-hmm. Greg, what's happening in Australia? Is Australia following the same journey as Scotland with this legislation, or is it taking a different approach?
No, it's quite a different approach. As far as I'm aware, what I'm seeing around the world is that Scotland is the only one who's going through the process of attaching property rights to digital assets, and I think that's really important. What I see happening elsewhere is that they're very focused on the blockchain side of it, or every jurisdiction seems to be very focused on the financial services sector. But what I love about this bill is that it goes far beyond the financial sector to potentially have a very powerful impact on farmers and fishermen, regional communities, and nature assets.
Thank you much, Greg. You've all kind of said that the Scottish bill looks rather elegant and you admire it because of those characteristics. Does that mean that the Scottish bill could possibly serve as some kind of international standard for defining law in relation to digital assets, or is it broad enough? Is it, are other legislatures being too specific and focusing in on particular aspects of this? Professor Schaefer?
I would definitely say for those legislators who think there's activity needed to regulate, it could very well act as a blueprint. There will be lots of countries where this is not high on the agenda, where they do not feel that there's a need to clarify the status, who are quite happy to leave an ambiguity. And that is another, if you like, ultimately policy choice. Misguided, I think, but a policy choice. Those that are interested in approaching this definitely should, I would say. With permission for my atrocious accent, I do think the bill more or less gets us where Austrian property law ought to be, had their judges not looked at German law interpreting the Austrian property law. Well, but that is essentially what the Austrian civil code said in the 19th century, doesn't make the distinction between different asset types and the way we did. So there is a historical confluence, I would say, of ideas, and taking the lead here, making it clear through legislative action, can only act, I would say, as a beacon for other countries considering the same thing.
Okay, Professor Robbie, is the Scottish Bill potentially a blueprint for others to follow, or is it too early to say?
Other countries may watch and see what happens. And those consequences may be good, but they may also be negative. So we would have to wait and see.
Okay, thank you. I'll leave it at that. Thank you, Convener.
Thank you. I'd like to bring in Gordon MacDonald.
Thanks very much, Convener. Good morning, panel. I'm just looking for some clarification about some of the stuff that we've discussed this morning. So this bill is very much a foundation bill, if you like. And we've talked, well, Greg McClarty's referred to, we need to have protection of farmers. Professor Robbie, you've suggested that carbon units have to be removed. So what should be the next steps for the Scottish Government if they're going to build on this foundation bill? Where should they look at next so we don't get out of date? Who wants to come first on that one? Professor Schaefer, you were...
I would bring in a totally different sector here, one that initially took on this idea of ownership very enthusiastically and very quickly, I think, moved away from it, the creative industries. The difference, both from the perspective of the creator, but also the ordinary buyer, between how the law sees their transaction and how they perceive their transaction is massive. People think of their e-books as their property, and in law it isn't. And this bill in itself would not change that, but it could create clever programmers an idea to compete with Amazon, to say, we find a way in which we make these books uniquely transferable, where you lose access once you have sold it, and so on further down the chain. These are all, I would say, blueprints that now go back to industry, told them, look, if you manage to adhere to that, the law will recognize it. And yes, as I said, for me, the creative industries would definitely be one of the potential benefactors. We know on the UK level, through the AI developments, the consultation on changes in intellectual property, that this is a very, very sensitive question that they feel very much threatened by big tech. This could be a way to steer just a little bit back against that, I would think.
Professor Robbie?
I think, as Professor Schaefer is saying, there may be steps that you have to take before the recognition then of an asset as a property asset is achieved. And so if there are problems that make or consequences of this bill, the government could regulate the steps that need to be taken before it achieves property recognition. For example, proper community engagement in relation to a carbon project that ensures that there is not just a monopolisation of the profits from a carbon trading scheme, for example, or a benefit sharing agreement between a landowner and a tenant farmer, or a landowner or crofter. Those are possible interventions that you could then put into this bill, and they might be relevant in different arrangements for different sectors.
Okay. Greg McClarty?
Yeah, my counsel is from someone who's implemented blockchain for 6 years now. Is that we've been really surprised with some of the impact that that's been had, and now with AI becoming much higher profile too, these two technologies will take us into areas that we just don't know just yet. Now, Professor Schaefer and Jill have both mentioned that what would be highly worthwhile is to have regular oversight or input with the committee and with Parliament. I think if they watch what we're doing and see the impact it's having on society and the farming sector and the health sector and more broadly, I think that's going to inform the Parliament about what needs to be regulated and legislated in the future, because it will go to places that we just don't expect right now.
Yeah, you just said we need regular oversight. Do you think the regulation making powers in the bill and the feedback mechanism within the bill is sufficient?
I would love again, selfishly, I think this legislation, no one, as far as I see, is doing this legislation this way with digital assets internationally, and so it firmly sets up Scotland to provide global leadership for what we see in the agriculture and food systems sector. And so if we could set up an advisory board, as Professor Schaefer and Jill have referred to, that is just focused on agri and food systems, I think that would produce extraordinary results and provide that advice back to relevant ministers.
Okay. My final point I was wanting to ask questions about was the expert group that all three of you mentioned that we require. But we heard the evidence from Professor Fox that in his view the UK Jurisdiction Task Force was sufficient because the advice that was given would be publicly available and neutral to any particular legal system. So what would you say in response to that? You raised it first, Professor Schaefer.
I think it is good that the task force exists, and I do think it will de facto provide some of the ideas that I mentioned, but it is not, in the English law at least, recognized as an official body. It isn't in the draft of the Scottish bill. I'm not entirely sure, given that Scots property law is very different from English property law, and we actually do have in Scotland quite excellent expertise in blockchain and digital technologies, that we should necessarily defer here to a group that has their centre of gravity in England. I'm also not entirely sure about the way their members are appointed. So that's why I still feel that there is space for a Scottish-specific group that combines lawyers, stakeholders, people from industry and technologists to figure these things out. Again, not acting as a second legislative body, not taking power away from the judiciary, but providing the type of guidelines that can help them to make sense of it.
I would agree with that. So I think because we have a different legal system, but really quite unusual elements like crofting, for example, that doesn't need a neutral guidance from a jurisdiction neutral body. It needs someone who understands how this affects crofting. And you're only going to get that in Scotland.
Good. Now, final word to you, Greg McClardy.
My sense is that the expert group down south is focused on financial services. I think this very special opportunity for Scotland is to extend the power of this technology past financial services.
Thanks very much, Convener.
And I'd like to bring in my colleague Kevin Stewart.
Thank you very much, Convener, and good morning. I think this is the first time I've ever heard a bill described as elegant. I think that if you'd asked us to describe the bill at the very beginning, it might have not been the word elegant that came to mind first. I think the other aspect of this, Convener, is I've never ever seen so many professors give testimony on a bill before, and it's really been quite interesting. I'm going to keep my questions quite simple, because I think that once again this morning we have learned a lot. Stephen has felt like he's in a conundrum at point. I think we've all felt that to some degree. But you've basically said that we have the opportunity here to ensure that we get this bill right, but beyond that, we recognise that there's still more to do. And there's been talk of specificity, but also talk of uncertainty. And to overcome that, it sounds like that we need to continue to monitor and scrutinise the effects of this as we move forward. Gordon just talked about advisory boards panel, or whether we rely on the UK. As I've sat here this morning and listened, is it enough that we have one advisory board or panel, considering all of the areas of business that we're looking at here? So my question quite simply is one panel, advisory panel, enough, or do we need to do more than that and make every government portfolio look at this and see what they think is required in their particular area of business?
I don't think I would necessarily suggest we should have multiple advisory groups, just knowing how there are stresses on public budgets more generally and time. But you might want to bring in various experts at various times to in respective industries, for example, or sectors, who can then provide advice to an advisory board. I think that might be the best approach when the matters arise or when an issue is identified.
Professor Schaefer, please.
Very, very much the same. I think this panel, this group, would need a really, really good convener who understands how the Scottish Parliament works, what different departments there are, and also probably has an overview of the technological developments, so that they can ask the right people. And that could be a slightly more official mechanism of requesting someone from a specific department to give evidence or to provide a report. But in principle, one panel and then delegation seems to be better than trying to figure out which of the existing groups should take the lead in a specific question.
Thank you. Mr. McClarty, please.
Yes, Heather Thompson and Peter Proud in the AI session both said something I thought was quite profound, that the AI and honestly digital trust and AI combined is going to be most powerful. And so there needs to be, they talked about a Team Scotland approach and a holistic government approach, because it is going to touch many different government departments and many different parts of society. And so my encouragement would be, whether it's in the First Minister's office, there needs to be something with that presents Team Scotland, bringing the impact of these technologies into government services and legislation.
Okay, thank you. Maybe the advisory panel is not the way forward. And Professor Schaefer, you talked about individual expertise. Maybe this oversight needs to be built in, as I think you've suggested there, Greg, into government itself at various points, with a recognition that a new breed of expert is going to be required, in terms of how we move forward on many of these issues. And as a Parliament, we've built in various rules around about ministers having to look at climate change, for example, or equalities, or the list goes on. Is this one of these areas where we maybe need to put that build in, that overview, as we move forward in day-to-day business? Or is that going to be too complex, do you think? Professor Schaefer?
I would be worried that it is too complex and then results in overstretched groups that have to comply with it in something that becomes more or less a tick box exercise where they go through the steps but do not really spot what is exciting, novel, potential of this. So that's why I would prefer probably to leave this on a level where people don't feel they have to comply with something, and in that way get the freedom to think about new ways of not just freedom to think about new ways, but how to best integrate these new ways that come from industry or academia or from wherever into our legal and economic system.
Professor Robbie?
Yeah, I agree with that approach. I think otherwise, yeah, just for those reasons that you said, Professor Schaefer. Yeah.
Mr. McClarty?
Yeah, I guess I've got the benefit of seeing that this technology takes you to places that you just don't expect. As I said earlier on, Lord Hodge and Professor Fox and Usman Tariq were extraordinary. I think if you bring my thinking is if you bring some extraordinary people together and they're presented with findings of what's happening with these technologies within the Scottish economy, I think people with profound intellect like that and seeing the bigger picture could provide extraordinary advice to government.
Thank you. I'm taken aback a little bit about your tick box exercise comment, Professor Schaefer, because I think that sometimes when we do certain things and we say you must comply with this, you must do this, it does become a tick box exercise, and I think this is probably one of those areas where that's the last thing that we want to see. I wonder if it could be a little bit cheeky, convener.
I'd be disappointed if you weren't.
Thank you. I was interested in what you said earlier, Professor Robbie, about carbon units and whether or not they should be property. I wonder if you could expand on that. And you also said that you tried to get some of this into the Land Reform Bill. Could you maybe give us a little bit of an insight around about what you were trying to do there, if I'm allowed to ask that, convener?
I think it's a really useful question.
Thank you.
So I was commissioned by the Scottish Land Commission to write a report on the operation of carbon markets and its interaction with land ownership in Scotland. So I co-wrote that, and when the Land Reform Bill was then published, I saw an opportunity for regulation of carbon markets more generally. But one suggestion I made was that there should be a public carbon trust, so that when units were created, they were held by a public body. Now, that could be the Scottish Land Commission, it could be Scottish ministers, or another body. And that body then undertook additional verification processes to make sure that any carbon processes or carbon unit processes were not having a disproportionate impact on tenant farmers or crofters or local communities. So people were not suffering in terms of agricultural tendencies, for example, or a community buyout that might be arising in the future. Basically, how other government priorities were ensured in the process of creating carbon units. I made various suggestions, but that was not seen to be in the scope of the bill. What did get changed is now it's in the Scottish Land Commission's Commissioner's role to investigate the operation of natural capital markets in Scotland. But to me, that is putting another, what I was trying to recommend was an intermediate step. So we put these units in a carbon trust, which is then, there's sufficient oversight of those units and the creation of those units, and then the sale of those units by government to ensure that this private investment, this market, doesn't have runaway consequences which are significant for a number of different priorities we have in relation to land.
I wonder, we've seen quite recently an explosion of folk buying land. Some have become large landowners very, very quickly. And in your opinion, what they're doing, has that had a really negative effect on smaller tenants, farmers, smaller landowners, because of that expansion, which a large amount of that will probably be down to carbon unit pricing, etc.?
So I think there was, when the codes started, there was a lot more of interest and heat in the land market exactly for this reason. And Scotland is seen as prime internationally because we have concentrated land ownership. So if you're an investment fund and you want to have a carbon offsetting scheme, buy an estate in Scotland. And so that's my fear. And previously, these large estates were seen as, they were money intensive. But if you can then change that they are then profitable, you create a possible intervention in the land market that could be very, very negative. And as we know, the Scottish Government has been trying to tackle concentrated land ownership for quite a while.
Basically. I'm interested in the fact, in your thoughts on whether or not those carbon units should be property or not.
So at the moment, I think that they shouldn't, because we don't have the controls in place. If we had a certain level of due diligence before they're recognised as property, then I would be more comfortable with it, as in there are steps before we recognise them. If you don't put in those controls, then I think there's a potential we're just creating a new asset class for people who are rich in resources already.
Okay. That is really interesting. I think, Convener, I won't go any further because we could probably spend hours on this. It may be very, very worthwhile for Professor Robbie's work to be circulated amongst committee members.
And despite your warning, Mr. Chair, I think I might just actually ask a couple of brief questions at the end, just to explore this a little bit further. Professor Robbie, is your contention here that essentially there are things that might be in the domain of permission-based or license-based, are therefore under the scope and ambit of government or the state, that you potentially sort of quantise and turn into property, and then you lose control? Is that at the heart of what you're saying might be the situation with carbon credits?
Exactly. So my fear is there are very basic requirements that you need to meet, and then you create a new object, which then becomes protected by A1P1. So for the carbon codes, there was no legislation that made that possible. It was the Woodland Carbon Code, the Peatland Code. There are voluntary codes. They're literally PDFs. And then there's a website that allows trading. And then people start paying for those things. And now we'll recognise them as property.
Yes. And especially because, I don't think that this legislation is intended to capture PDFs, but...
No.
that if you have a situation where those PDFs arise from an electronic system,
well, no,
and contain some sort of record, and I'm quite sure that you could come up with some sort of clever way of embedding that. Then those and that those are have contested claims over them. And let's also be clear, we've also already heard that a mutability test is not absolutely concrete. In the end of the day, these are just electrons sitting on hard disks. Yeah. So it's a notional immutability rather than a hard, practical, this is unalterable in any way. It's actually sort of it's a theoretical immutability. Yeah. Then those PDFs, even those PDFs themselves haven't been designed to be, could become essentially electronic property or digital assets. And is that essentially what you're saying?
I'm not talking about the PDFs.
No. But I'm just saying that a system that has been created out of PDFs that people might have think are a world way, actually all of a sudden it can be argued that they meet the criteria set out here. Is that?
Yes, when I try and explain carbon units sometimes to people, I suggest that, for example, my university wants me to do active travel. So for every kilometre I run or cycle to work, it might give me an active travel unit. And then maybe these are exchangeable, so we have to have 100 active travel units. But somebody who wants to sit at home can buy my active travel units from me. Something as simple as that, if you give it a serial number and you put it on a website and then you need to trade them and you meet certain criteria, you could end up getting into the same, it can meet these kind of property assets. Now, for my active travel unit, it's not actually a problem. For Scotland's land ownership and potential concentration, further concentration, and the impacts on local communities, it can create problems.
Yeah. So I think you hit upon something that right at the beginning I had a concern about. That you essentially, if you created a document that had some sort of restricted control mechanism, but just had sort of version control, just saying, whose hands it had passed through, do you inadvertently create something that gets captured by this? I'm just sort of checking that essentially we're in the same terrain here.
Yeah, I think that over the period of history, we have, when things become valuable, often there is a legal claims about the ownership of them, and can they be separated from other things? So minerals, coal, for example, can we separate them from land and then transfer them separately? And that happened at particular moments in time, and they're called separate tenements in Scotland. We're almost allowing that to happen for digital assets, but without an idea of what this could be applicable to and then what the consequences are of it.
And I guess, and I'm just going to, I'll bring in Mr McClarty in a moment because I know he was keen to come in. I guess the other point here is that this is a bill that creates those things, but then actually says nothing actually about how and when those things may be exchanged. It just sort of essentially, because these are, I think whether we like it or not, these things are actually being, the ownership and exchange actually looks quite different to regular property. And yet, actually, so we're bringing these things into the property law, and we're not necessarily reflecting how they might then get handled, used, or exchanged, despite the fact they are different. So, I think both inadvertently maybe bringing things into this, and then really saying nothing about how they handled. Is that a fair sort of summary of the things?
Yes.
Yeah. Mr McClarty, I know you were keen to come in on some of these points that we've just been hitting on. I'd be interested to know your views and whether you concur with some of the points raised.
Thanks, Convener. Yes, as I stated in the very beginning, Convener, I'm shoulder to shoulder with the dysfunction that's come into the market from the wildland and peatland codes. And it's dysfunction on many levels, and it has to be addressed. But the point I want to raise, Convener and committee, is that for a working farm, There's international protocols developed by the EU that are recognised internationally as the best protocols available that provide step-by-step exactly scientifically how to measure soil organic carbon. It's a real thing that's measurable in the soil, and it can change over time, showing the carbon sequestration in the soil. So that's definitely an asset that should be captured for the benefit of farmers in terms of additional income streams, and recognising what the carbon stewardship, the very important role of carbon stewardship that farmers undertake. So I want to make sure that that's the difference between productive farms and soil organic carbon measurement and as an asset versus the issues with woodland and peatland code.
And Professor Schaefer, just for completeness' sake, I mean, do you have any thoughts about the sort of the things we may be inadvertently capturing, and therefore, what potential sort of safeguards or thoughts might we have just to guard against that?
Definitely not ask me in my German capacity, because there's absolutely nothing happening there. As I said, Austrian law probably being historically at least meant to be where Scotland is moving now. I think the way Robbie described it makes perfect sense. If we look at carbon credits or similar assets, the value that they have, not the asset itself, but the value, that is because they are recognized, for instance, by the Scottish government, for instance, by a trading body. And it is at that step where you turn the mere ownable thing into something that has then value, where I think quite a lot of scrutiny has to happen, a lot of legislative backed up diligence has to happen. But that is, for me, the second step. First, we decide this can be owned. And then we say, okay, if in addition you meet these following requirements, then you are also tradable in Scotland, recognized by the Scottish government for bookkeeping purposes, that sort of thing. I would keep these separate. I would say a property law act need not deal with them, but definitely also for the benefit of the committee, these things then have to be taken place in their respective fields and sectors.
Great. Well, with that, I think we'll end the public element of our meeting this morning. Can I just thank all of our panellists for what has been yet another, I think, very interesting and very insightful set of contributions, and hugely helpful, although I think we have a huge amount to go away and think about. Thank you very much. And with that, we move into private session. Thank you.